Okay, there we go. All right, now let's turn the volume down a little bit. All right, maybe the Lord heard us initially. What do y'all think? We've got some guests here with us today. We've got some members of our judiciary. Judge Matt McCord, president of the Municipal Court Judges Council from Stockbridge. Judge, good to have you. Thank you for coming today. How are things in Stockbridge? Okay, if you did, would anybody care? That's my problem. All right. Judge Charles Barrett, Legislative Chair, Council of Municipal Court Judges from Duluth. Judge, good to see you again. You've been down here before. All right, good. We appreciate you being here with us. I think we have a couple of Superior Court judges with us, Judge Brenda Weaver and Judge Stan Gunter. Thank y'all for being here today. Y'all keep it straight now, okay? If I need somebody held in contempt, you'll help me, right? Okay, there we go. Yeah, I'm watching Mary Margaret over there, so. All right, and also we have Barry Morgan, Solicitor General of Cobb County. Good to have you here. You got a great name.
Thank you.
Yeah, good to see you. We must be. All right. Let's see. I think Representative Belton, are you here? Didn't you ask to go first because you got to be somewhere important?
I've got another bill in education.
Education?
Same time.
Well, come on. We'll get you out of here anyway.
If you don't mind, Mr. Chairman, I'm bringing two guests with me.
Bring anybody you like.
Yes, sir.
I'm going to turn on both the witness mics over there, Representative Belton. So.
Thank you, Mr. Chairman. Probably the most ignorant person in this room right now, so I need a lot of help. To my left is the
theme is everybody needs a good lawyer, right?
yes, sir.
Okay.
Everybody needs a good lawyer. To my left is Lieutenant Colonel Brad Carver. Brad Carver's been in many, been to Afghanistan and Iraq. He's retired, a very good friend of mine. You want introduction, sir?
Sure. Brad Carver. I'm a retired, actually, Thanksgiving Day this past year, 28 years of Army service, field artillery first, and I finally got smart, joined the JAG Corps, where I got to meet gentlemen like the real experts over here to my right. But I have served my entire career in the U.S. Army Reserve, so I am here to shed a little insight from the Reserve House as opposed to the National Guard side of the house. I've had a couple deployments during my time. Actually been stationed in all 5 of our Army bases in Georgia. But I wanted to tell you from a soldier standpoint, I think this bill is very important in terms of what it means for soldiers. And then I'll also tell you that because this is a very much a military state, a heavy Army state, that this is good for protecting our bases and making us military friendly, which is really keeping with the theme of what this General Assembly has been doing over the last several years. We appreciate all that, and I'm here to both to shed light as a soldier who has deployed many times, but also as a JAG officer who has advocated and advised soldiers when they're facing situations like which will be presented today. Thank you very much for your time.
Mr. Carver, I know you mostly as a good lawyer, but we also appreciate your service to our nation. Thank you very much for that.
And thank you, sir, Mr. Chairman. To the right, I have Colonel Joe Ferraro, who's also a lawyer and works with the National Guard as a legislative liaison. Colonel?
Certainly.
And Joe, what's your last name?
My name was Ferrero.
Spell that.
F-E-R-R-E-R-O.
E-R-O.
Yes,
Colonel,
sir.
thank you, sir.
You're very welcome. Yes, I'm Joe Ferrero. My job title is I'm Deputy Adjutant General for the Georgia National Guard. I am retired colonel with 30 years service, 6 years active duty, and 24 years in the Guard with 9 deployments throughout the Middle East and Europe. During the Bosnia and Yugoslavian wars. So we have 2,200 guardsmen who are deployed to Afghanistan right now, and from our perspective, this bill would be very helpful. We would add this to our mobilization line. We already deal with the Service Members Civil Relief Act, which is a federal law, which does protect military members in loan situations and lease situations and so forth. This would be a good addition from our perspective. We could have letters pre-prepared as the soldiers and airmen are going through the mobilization lines. You know, we could ask them if they've got any this sort of telecom situation that we could help with at that point.
First of all, Colonel, we appreciate you being here, and we thank you
You're
for
very
your
welcome.
service also.
You're very
Tell you
welcome.
what, how about we proceed this way?
Yep.
Representative Belton, why don't you begin by explaining the bill to us and tell us what it does?
Of
and then
course,
we'll
sir.
come back to some more comments.
Yes,
How
sir.
about that?
Just want to show you a couple documents. The first document is a color page. It's actually a letter or a document from the Pentagon. The red is the things that they request Georgia to work on. This General Assembly has passed 23 new military-friendly laws the last couple of years. We really appreciate y'all doing that. This is just another couple things that the Pentagon would like us to work on. The last one in red at the very bottom is increased protection under state supplemental service members, the Civil Relief Act provisions, and that's what we're talking about today. The second document is a little, again, a DoD Pentagon document talking about the importance of this in layman's terms. And the third document is a letter from the Pentagon specifically talking about this particular thing. Again, there is a federal service member civil Relief Act. However, there are certain things that is not covered by the act that they'd like the different states to do. 17 states have done this already. The legislation we're talking about. 3 other states are doing it as well, and our military rival states are some of these states that have done this, and that's why we're asking to do this. Basically, it's allowing a service member, if there's one thing is hard to understand, but when you say service members, there's some active duty people, there are reserve, Brad was a reservist, and there's National Guard. Colonel Ferraro is a National Guard. But sometimes these reservists and National Guard become active duty. And that's where the crux of the situation is. And
Representative Belton, the chairman of the subcommittee, I believe that the bill came out of, wants to make a comment. Representative Mr. Whip?
It wasn't my subcommittee. I think
It was not?
Chairman Welch, but I have a question about, as I'm just trying to go through the bill, which LC number. I came in late, and I apologize.
yes,
No,
sir.
no problem.
I'm sorry. It's a Lima Charlie 41 1760 Sierra.
Chairman Welch, you want to address that?
Yeah, let me address that if I could, Mr. Chairman. Thank you. Majority Whip Kelly. There are 2 bills in your folder. One is LC 411760S. The other is LC, and then there's another one in there that is LC 491759S. 59S is the version of the bill that we passed out of subcommittee. And the difference is that if you look at if you look at 60S, at line 40 through 41, you'll see language after the word 90 days, the phrase 90 days, you'll see language to a location that does not support the ability of a service member to receive identical contracted services under the contract. This language was originally in the bill filed by Chairman Belton. In subcommittee, we looked at this language. We voted to strike this language after further review and some information coming back from the cable companies and the companies that are affected by this. A redraft of the bill was proposed to put the language back in.
Okay.
And so you have that version there, and you have 2 versions, and that's the only difference between those 2 versions is one has that language, one does not.
So we're gonna get to both of those versions and talk about which one that may be best for us. But let's do this first.
And I'm sorry for interrupting, Mr.
No,
Chairman.
not at
I
all.
just wanted to make sure that I was reading through it. I knew which one to consider.
I think the majority whip can always interrupt. So I understand. Why don't we do this first? For those people who did not serve on the subcommittee, is I understand that what we have in front of us is a proposal from Representative Belton to help our service members who are being deployed and how they deal with certain contracts that they may be under. As I also understand that federal law already relieves them from several type contracts, but there are some things which it does not. In our situation, for example, I think we've dealt with rent before. I don't know if we've dealt with cable, for example, because that's one thing that is in your bill, I believe. So the purpose of your bill is for us to help service members deploying and how they may or may not have to deal with a contract that they're in and get some relief from that. Is that a fair generalization of what we're dealing with?
Yes, sir, Mr. Chairman.
Okay. And so what you're telling us also is that there have been some studies, it sounds like at the Pentagon level, and they have asked us as a state, particularly a big military state like we are, could y'all take a look at some other issues regarding contracts that may be helpful to our service members? And that, to some extent, is what got you to think about this legislation. Is that right?
That's correct, sir.
Okay. So why don't we pick it up from there and you tell us what more details you want to about the bill, and then we'll go on. Okay.
Yes, sir. Well, basically, again, it only in case a service member is activated for a period of more than 90 days or longer. That's in line 30. We're only talking about provisions for television, video, audio programming, or internet access in line 35, line 37, or services by health spa. Now, and then in lines 39 through 41, it talks about the this only applies if the service member receives military orders to relocate for a portion of 90 days or longer. And then in line 44, only if you have written notification of termination of the effective date is at least 30 days before the contractual parties receipt of the notice. In line 47, you also have to have the military orders in hand or signed by the commanding officer. And of course, this bill would not take place until July 1st of 2019. And that's the crux of the bill.
All right, so let's do it this way, and Mr. Carver or Colonel, y'all welcome to jump in here. Generally, what does federal law already cover when it comes to contracting soldiers, or Representative Belton, whoever would like to tell me that?
My experience with the my experience with the
In the area of contracts,
Right,
and,
yes,
and
sir.
having to break them, yeah.
my experience with the Service Members Civil Relief Act, which was formerly known as the Soldiers and Sailors Civil Relief Act, deals with interest rates and some leases.
Okay.
And I did not have any experience, I have to say, with overall contracts in general. But I know, and it does apply largely to reservists and guardsmen, being a type of reservist, that you could terminate those deals if you were a part-time reservist and then you got mobilized and sent overseas. If you were an active duty member, a lot of times you could not take advantage of those things because you made contracts on the basis of your salary and so forth, being on active duty.
You knew where, more
Right.
so than the guy who was in the reserves. Okay,
Right.
Gotcha.
I will say a large proportion of our soldiers in the Army National Guard are between the ages of 18 and 24, and a lot of young single men and women. And so, if you have a contract under one of these provisions, one of the telecom provisions, if you're single and you have your own apartment and all that, you leave, there's nobody there to take advantage of it. The older folks who are married and all that, I mean, their families are still going to be there,
Right.
so they wouldn't need to take advantage of this.
Gotcha.
It would really be for the
So this bill deals with which kind of contracts? Telecom?
Just as telecom and health spa. There's actually a list. If you look at this document here, the letter by the Pentagon, the 2 bullet points. It's in 2003, the SCRA had covered stays for court proceedings, protection from default judgments, evictions, foreclosures, loss of insurance coverage, and limited certain taxes and obligations. And the updated 2003, it also covers residential leases, motor vehicle leases, automobile mobile service, these things as well. What the Pentagon is specifically requesting is this health spa and also this the provision of telephone, video, and audio programming that's in line 35. In line 37, the health spa situation. So it's basically trying to clean up it.
Can I have that memo, please?
Yes, sir. Did y'all not get one of these?
If I may add too, it's
Sure.
As we've said, the purpose really is to protect the reserve component.
Sure.
For all the reasons that have been said. In 2003, obviously, that's when I deployed to Iraq. And served with Representative Holcomb on this committee when he was on active duty in Iraq. When I came at that time, we had many reservists that were getting mobilized. Prior to the first Gulf War, there weren't that many mobilizations. So what was decided at the time in 2003 was it needed to be modernized, which is why we have the new language. It increased the services, and I think perhaps there will be an attempt in the future to have federal legislation that brings it even more up to date. But in the interim, and especially since we're such a heavy military state with so many National Guard, 15,000 National Guardsmen, thousands of reservists, along with our active duty soldiers we have in the state, to cover us at this time before there's new federal legislation, that's the attempt to do this, is to expand
Gotcha.
it to these areas.
Okay. Chairman Welch, you were chairman of the subcommittee, right?
Yes.
Any general comments you want to make before we go around the room?
Just that is an accurate description of our hearing, and that's all.
Okay. Questions for Representative Belton or one of the two witnesses from any members of the committee? Okay. Okay. Representative Welch, Chairman Welch.
Just to clarify, because we are talking about the two different versions of the bill, the language, and we had a discussion about this in subcommittee. The telecom industry was not present for some discussions with that, but I think it would be important if you would elaborate specifically, Mr. Carver, as to why the language in lines 40 through 41 should be re-added to the bill in this version, because as I understood it, that the advantage of that language was it did still allow for someone who had a good package deal to take that deal with them to another location. And if we remove that language, then what you're doing is the effectiveness is that contract is terminated. So that was the advantage of that language being in there. And so if you could just elaborate on that or add.
Sure, I'm happy. When the question was asked in subcommittee, specifically about that, because I think there was an attempt by the committee to make it even more favorable to the service member, and we certainly understood that position. I made the comment that in the other states that had considered this prior to Georgia, the other 17 that have enacted it, the 3 that are doing so right now, including the states that are our immediate neighbors, that the concerns of the industry were that this would be the better way to handle it, protecting both the soldiers' interest as well as the industry's. And I do think to some degree that was a compromise that was reached in those other states. I will speak on behalf of myself. I think that the language as it existed prior to the committee substitute was sufficient to protect soldiers while at the same time being fair to the industry.
And that is LC 411760S.
Correct, sir.
That's correct.
Okay. All right. Okay. Representative Walensky.
Thank you, Chairman. The bill makes total sense to me. Just my one question is regarding health spa used under the code section 101392. It excludes any nonprofit organization or any facility owned by a doctor. And so if a person in the Army was a member of the YMCA, they would not be able to use this bill. So I was just wondering if we want to
on
open
line
this up.
36 it says membership or provisions of a health spa notwithstanding any provisions in 10.1.33.90 in 393.2.
I'm on, thank you, Chairman. I'm on line 27, health spa, the
27?
definition. Yeah, health spa defined shall have the same meaning as provided. Thank you, Chairman.
No, go ahead, make your point. You
So,
got a good point.
so in order to get the full breadth of this bill, I think it should be broader than what is defined in 10.1.392.
do you
'cause
want
there's-
Brad? Do you want to look at 10.1.392?
Yeah,
You want to pull it up? You want us to pull it for you and let you look at it,
that would
or
be-
do you not need to?
No, I do.
Yeah, right there. I'd be happy to entertain anything that would strengthen the bill, sir.
This is the definition of health spa. Can you see it okay? Yeah.
All right, with 14, try it now. Yeah, that's fine.
It seems like there's two different code sections. 392 is mentioned in line 27, and line 38 it's 393.2.
Line 36 and line 37 seems to be we're not going to pay attention to that code section. It's not going to be affected by what we have here because it begins with notwithstanding. So I think the one of interest is the one that Representative Walensky pointed out on line 27, which I think Mr. Carver's looking at right now.
I mean, this is a very broad definition of health spa. And so I guess what I'm confused about is this, the subsection 2, 393.2, so that's a different section.
At 393.2.
Mr. Walensky, you caused this problem. You want to help us solve it?
Yes, Chairman. Once if it was highlighted, I apologize, but 101392 has two exclusions, and I just don't think that this bill should have those exclusions if we're trying to help our service members be able to leave all contracts dealing with any gym or anything like that. So,
I think I see his point.
yes, sir.
You know, without having familiarity of why that, I mean, we certainly are supportive of the change.
I would say this language came from the Pentagon, so this is, but if you want to strengthen it, that's fine with me.
I think it would strengthen it. I mean, that's clear. I think the point that the member's making is that this would be more beneficial to the service member, and that the reason for the distinction doesn't appear to be needed in this case.
Mr. Whip?
You know, I think it would, you know, I'm guessing that this was drawn up referencing that code section out of ease and clarity in drafting. I'm thinking what if you want to take those exceptions away, you just put the language in that's defined, and you strike in 10392 everything after or by other terms of similar import, because then it goes into a health spa shall not include any of the following. And so if you just take the definition as is from 101392 number 16 and just delete all the exceptions after it, but insert the actual language on the beginning, that would be the way to do it.
Tell me again how you're going to solve this problem.
That would be an amendment that I'm offering. With,
Yeah, but you adding language into the bill or taking?
I would strike
Uh-huh.
health. I would strike. It would say health spa shall be defined as, and then I would start with, or it could say health spa means an establishment which provides, as it is in 16, and go all the way down. And I would just strike the language that says a health spa shall not include any of the following. And I can give that to Julius.
I'd be happy with that change from the whip.
How many lines you talking about? Yeah, how many words?
There's several. And I think there honestly needs to be a debate about whether we want to strike just the ones that Mr. Walensky has in of any nonprofit organization, or if there's some that we want to keep in. There's 3 exceptions in 101392 number 16. Any nonprofit organization, any facility wholly owned or operated by a licensed physician, and then any such establishment operated by a healthcare facility, hospital, intermediate care facility, or skilled nursing care facility. So if we want to do away with all 3 of those exceptions, because my understanding is this code section was originally set up for regulation and oversight. It was not for contractual purposes. So if we want to take those out, then my proposed amendment would fit.
The chair is reluctant to try to do that on the fly right here, and the choices would be twofold. Maybe 3. We could send it back to subcommittee and y'all could perfect it there. Number 2, we could take the next 2 bills, and if you want to try to do something in probably about 20 minutes, you're welcome to give it a shot. Or number 3, I don't mind holding the bill, and my suspicion would be that we will probably meet on Tuesday of next week. Yeah.
Get it drafted up if you want for him to offer as the amendment.
I will be glad, based on what the chairman decides and the representatives, Chairman Belton's desire, if you are okay with us doing it in the immediacy, I will be glad to step outside and help him draft it and come back in, since he has witnesses here with him today.
You can give it a shot.
Okay.
So, tell what the chair, Miss Oliver, you want, what number are you? Well, just press the button and yeah. We got to get all the mics checked. Try 15. Okay. Jiggle it a little bit there.
reinserted in this, about the, and I wanted to just have a very, very short discussion about that. I'm respectful that
Sure, go ahead.
industry people were not here, when we first discussed it. My impression is that packages and internet change on an hourly basis. And the idea that somebody is gonna, a serviceman's gonna be able to really understand the package driver in Montana or California, it just seems like an overly burdensome application of a new duty. And that was the original purpose of our thinking about the amendments. But I also don't think that we should ignore the fact that the industry is not able to be heard here.
Well, we don't have anybody signed up as a witness, else to testify. We could certainly hear anybody else that's here that wants to testify to the bill, but you have to let me know, because nobody signed up.
Can I just make a comment about that? There also, and I think this, that Chairman Welch made this point as well, there is a situation, because I did have this conversation with the industry immediately following the subcommittee hearing, and there was a concern as well for the protection of the service member if they had a more favorable package, meaning, I mean, I guess the thing that came to my immediate mind, maybe because, like y'all, I'm very busy, DVRs, you have a DVR package. If you have programs saved on your DVR, then if you can go from Georgia to Montana and it's the same package, it would be preferable usually to the soldier to not lose the hours of programming on the DVR. That was the example that came immediately to my mind.
Most of the packages, they give you a very good deal for the first 90 days, and then it shifts. And that's my experience. So the idea of trying to compare this package to that package, I don't know what a DVR package is.
Okay.
I don't have a strong feeling about the amendment we discussed, but I'm just trying to really figure out how a serviceman is going to be able, a woman is going to be able to figure this out, and I can't figure it out with our own package changes.
Okay. Other questions or comments? Mr. Holcomb, is that you? 16? Try it now.
Okay, thank you. In thinking about this, I think in terms of the impacts of the industry, I'm very supportive of what they're trying to do, and I think Lieutenant Colonel Carver would share with you that when we were deployed, people were still writing actual letters with paper and sending emails with Hotmail and other things like that. And the world that we live in today is much different. I had a flip phone, and it didn't work, of course, where we were. But today, if you deploy with your mobile phone, many of the carriers, they have wireless calling, and most of the bases, except for those that are in kinetic operations, have access to Wi-Fi. So you can still use your mobile phone across the world, and you can use it for text messaging and everything else. And because a lot of people wouldn't want to lose their numbers, because then that's how people know you today, is I actually think that the number of service members that would take advantage of this and disadvantage the industry is probably quite low, and it would be in circumstances that we are truly going into a combat situation where for a likely long period of time they're not going to have the infrastructure set up to have the Wi-Fi and the other things. So I think that this is a very helpful measure, but any impact on the industry I don't think would be dramatic at all, at least with respect to our devices and the telecommunications aspect.
Okay. All right. Unless there are any further questions or comments from the committee, we're going to suspend on House Bill 25, and the chair will entertain it when we get through with our other two bills, if you have something you want to bring to us, and at that time we'll make a decision about whether or not we'll try to do it here, or we'll do it maybe. I don't mind if we have to hold it over till next Tuesday. I think we'll have a meeting on Tuesday, probably so. Yeah, I don't mind calling a meeting just to deal with it on Tuesday, if need be. But I'll, at the end of the meeting, or these last two other bills, I'll let y'all talk to me, okay? Sound good? All right.
Thank you, Mr. Chairman.
Thank you. All right. We'll suspend on House Bill 25 for now. Let's see. Mr. Rutledge, is your bill going to be easier than that one? All right. You want to? Would you like to present from right there, or would you like to present from right here? Okay. All right. Do you have anybody you want to bring up?
I don't.
Okay.
I mean, Matt might want to say something, but I don't.
Okay. All right.
Okay.
So
okay.
the
This is
chair will call House Bill 92. Representative Rutledge.
Thank you, Mr. Chairman. Is mine on? It is. Okay.
Yeah.
Working off of LC 289044 ER. This measure is brought to us by our municipal court judges. Simply want to be able to carry over their training hours in excess of not to exceed 6 hours of training. That they're required 12 hours each year, and when they take training and exceed those hours, this would allow them to carry over those training hours to the next year, but not to exceed 6 hours. And that's what lines 12 through 15 would do.
When I first read this, I said it sounds very similar to what attorneys are allowed to do, to have some carryover CLE, and so it seemed pretty simple. Do I have 92 in my book? Yeah, you do. Oh, that's right. I see. I got it. Okay. All right. I know we have a couple of municipal court judges here with us today, Judge McCord and Judge Barrett. Do y'all want to make any comments? Other than it's a good bill?
I don't, Mr. Chairman, it's a good bill.
Okay, good.
And I'm just carrying it, hopefully find favor if I ever have to go before those judges. Some odd chance.
Well, we all right. Well, it's,
As your attorney, I advise you to track that.
okay, Representative Dreyer, is that you?
Yes, Mr. Chairman. Thank you. I just wonder, why are we doing it upon the request of the municipal court judge instead of making it automatic?
I asked. Okay.
Come on, Judge. Come on up here and let's turn the mic on because we are on TV, so to speak. Welcome. Good to see you. Go ahead and introduce yourself because our mass viewing audience may not have heard that earlier.
My wife's watching at home.
There we go. Okay.
I'm Matt McCord. I'm the president of the Council of Municipal Court Judges. The question you raised, we presented to our training council. We had originally put it in there that it would be automatic, but it isn't always the case that somebody needs that. So what happens is a judge may be delinquent in 1 year because they weren't able to attend. So when that judge makes the request, it then would go to our training council, and the training council would look at it and make a determination as to whether they had, in fact, the proper number of hours to carry over, and then that decision would be made at that level. So we felt like it added a layer of scrutiny to ensure that our judges were trained properly.
Yeah. That's great. Thank you.
Yes, sir.
Any other questions of Representative Rutledge or Judge? Okay. Anybody else think? You can hold on for 1 second. Representative Welch?
Motion at the proper time.
Okay. Do we have anybody else signed up on this particular bill? Okay. The chair will accept, unless there's any further comments from members of the committee, the chair will accept a motion.
A motion for due pass.
Second.
There's a motion for due pass and second. Is there any discussion? Hearing none, all those in favor indicate by saying aye. Aye. Any opposed? The bill moves on to rules. Thank you, Judge.
Thank you, sir.
All right. Next will be House Bill 91, and that would be Chairman Welch. Chairman Welch, you want to present from there? Yes, sir. Is there anybody you need to bring up?
I might need Joe Hood, but we'll just see. I don't think if there's questions, we can bring him up at that time.
Okay. Let's see. Representative Silcox, did you want to say something before Representative Welch begins?
I appreciate it, Mr. Chairman. I was just going to ask Representative Welch if he could share, because he had a wonderful fingerprinting bill last year, and was just curious if this was any kind of a follow-up, and just to give a history for our freshman members.
Yes, ma'am.
Okay, include that in your introduction, I think is what she's asking you. Okay, good question. Go ahead, Mr. Chairman.
Thank you, Chairman Silcox. This is actually language, for the most part, that was included in a bill that the House considered last year, and the program that we approved, the governor signed into law in Senate Bill 316 allowed the GBI to create jointly with the FBI a fingerprint retention system that if and only if a department or state agency chose to subscribe or participate in this system, then it would allow them to retain the fingerprints of employees or designated individuals, contractors, licensees, and that who are seeking permission to undertake an activity, usually with individuals that are our most vulnerable populations, such as our children in decal, such as our children under treatment through DBHDD, behavioral health, through also our caregiving institutions, and where we have children that are foster children that are maybe staying with the state, even foster children themselves and the parents that will take them on. But the bill was broad in its scope before. We narrowed it down and added language that really focused on two agencies in the Senate Bill 316. What did not make it through all this was fingerprinting authority. The program's called RAPBAC, R-A-P-B-A-C-K. That's how it's known in the industry. And what did not make it through was with the Department of Community Health. And Department of Community Health, as you know, oversees and the licensing of our hospital systems and those that are contracting to build hospital facilities, which is covered in this bill, which would allow them to participate, allow DCH to participate in the RAPBAC program. That's Section 1. Section 2 would allow for these are employees that are handling long-term care background check programs. So this is long-term care facilities, and those that might be providing those services could then be a part of this system. And then finally, we added in Senate Bill, I think it was 406, we were dealing with the Central Caregiver Registry and the formation of that registry so that caregivers would be known and identified as whether they were licensed and authorized to be a caregiver under Georgia law. And this legislation would add them to that system. And in every one of these situations, a background check is required. The distinct difference is that it's required at one point in time. For example, if you take the background check of someone seeking a license or to become a caregiver or to work in long-term care, you only know the criminal background as of that date. You do not know the criminal background from that date forward. And we only require a routine update of your background check either on a 12-month basis or a 3-year basis or a 5-year basis, depending on what the agency is and what the issue is. Within that 12-month period, 3-year period, or 5-year period, the agency has no idea whether the caregiver, whether the employee that's overseeing children in a Department of Behavioral Health situation has had a criminal incident that would no longer make them qualified to provide services to that child or that elderly person. So RAPBAC was put in place so that could be an ongoing trigger, so that if someone were picked up for an abuse situation in another state, then the department could be notified that that employee, that caregiver, that institutional employee was no longer qualified to administer care over that child or that senior adult. And so the department now is asked to join that program so they can have that instantaneous update on one's criminal background. And that's the nature of this bill. It simply references the code section that authorizes GBI to retain those fingerprints. And the agency feels like that it's in the best interest of protecting the citizens for whom that they're administering these services, those that are most vulnerable and under the care of individuals licensed by the state, to ensure that those individuals that are providing that care are qualified at the time that they sign up and remain qualified while they have the permission of the state to do that activity. And that is a long summation, but I hope a thorough explanation of the bill and what it's intended to do.
Okay. Questions from the committee for the author of the bill? Representative Silcox.
Thank you. And thank you, Chairman Welch. And I was just curious, I know that last year there were some concerns about the security of this. If you could just talk about that a little bit, that was a big deal.
Yes, that was raised. The important side of this is that language was included in the legislation. Both my my original bill and then what subsequently was passed and signed by the governor in 316, Senate Bill 316. And expressly, our law requires that there is no commingling of an individual's background history with the criminal background. So there's a difference between this is an employment non-criminal background check system. So it is separate and distinct from our GCIC system. They do not marry, they talk, but they do not share, the data doesn't cross over. And the other part of this is that it has to be maintained in a secure database, just as we maintain our other criminal background checks or criminal background history in a secure system as well. So legally that's required, and GBI has already started the program in this off session, and they've been building this program and working closely with the FBI to make sure that these systems work well and are integrated appropriately. And this is a federally authorized program, but the state must adopt it, and we have adopted that now. Agencies that were left out before would like to join and be a part of it going forward.
And I just add, thank you so much for bringing this, Chairman Welch. I think this is so critical due to the fact that we've had such an increase because of the opioid crisis and what have you. We've had the number of foster children in our system has tripled. So I thank you for bringing this.
And just think about the elder abuse that we've been attacking for the last 3 years, and that's where this is very important. I mean, this will be an essential tool to that mission.
Thank you.
Okay. Any other members have questions for the author of the bill? Okay. And I do not have anyone signed up as witnesses. So any further comments from the committee before the chair accepts a motion? If not, is there a motion regarding House Bill 91? There's a motion. There's a second. Any discussion? Hearing none. All those in favor indicate by saying aye. Aye. Any opposed? The bill moves to rules. Congratulations, Mr. Chairman.
Thank you, Mr. Chairman. Thank you,
All right.
members.
Mr. Whip.
Yes, sir.
Do you have a whip's report?
I do. There should be a amendment that could be passed around to the committee right now with my proposed amendments. And I don't know if we can let Chairman Belton know that we're about to take things back up. They're still back there. Maybe. But essentially what I did, Mr. Chairman, everybody can see it as it gets passed out, is I just took the definition.
Pulled your mic around there, Mr. Whip.
I just took the definition that existed in Code Section 10.1.392, and I struck essentially all the exceptions that existed at the end of the definition.
So we're going to insert a new definition into House Bill 25.
Yes.
Basically, that is already been written elsewhere in the code.
Yes, sir, Mr. Chairman, minus a few exceptions, narrow exceptions. And my amendment would be simple. It will just say strike line 27 and insert, and that'll be the language before you.
Here you go. It's a cheap one. And council makes a good point. We're talking about amending LC 411760S.
Yes, sir, Mr. Chairman.
Okay. I'm sorry? Well, the bill is before us, so the chair will accept an amendment to that LC number when we get time to make it. Is that all right?
He's trying to say it was tabled, but the bill was not tabled because you just
Just suspended.
No, I didn't. No, that's not what I said.
Move to pass.
Move to pass and then state the bill number so that we have that before us.
Mr. Chairman, I move that we pass House
Hold
Bill.
on one second. Hold on a second. All right. Hold on a second.
No, you can't.
So what we're going to do is that Mr. Belton, you've reviewed the whip's amendment and you're fine with it, and so
Yes, sir.
And so is all the brass with you, right?
All the brass, yes, sir.
Okay.
Yes, sir.
All right.
Now outrank me.
Okay. So what the chair is going to do here is see, is there any discussion regarding what's in front of you? Has anybody got any questions about it? The chair is going to hear a motion that it be added as an amendment, but does everybody understand what we're doing? Okay. All right. So, Chairman Welch, did you have a question over here, Representative Silcox? Okay, I think Chairman Welch beat you to that. Chairman, but I'll let you second it. Chairman Welch, you want to move on an LC, and then we'll take up the amendment?
That's right.
Here you go.
Mr. Chairman, I'd like to recommend do pass on LC 41-1760S.
Okay, let me have that back from you. Second by Representative Silcox. Okay, there's a motion and a second, so we have in front of us discussion, and I also know obviously we're going to have an amendment. Any discussion on the motion beforehand? Mr. Whip, you want to make an amendment?
Yes, Mr. Chairman, I would offer the printed amendment that sits before the committee.
Okay, and that would be like striking line 27 and inserting the definition of health spot that we've already discussed.
Yes, sir, Mr. Chairman.
There is a second to the amendment?
Second.
There's a motion and a second. Discussion on the amendment. Hearing none, all those in favor say aye.
Aye.
Any opposed? The amendment carries. Now we have in front of us LC 41-1760S as amended.
It's going to be just a committee substitute.
Okay. We have the bill as amended in front of us that we will pass as a committee substitute. Is there any discussion regarding that? Hearing none, all those in favor of passing as a committee substitute LC 41-1760S
You can't give an LC number.
House bill?
Because we're going to get a new LC number, so you're just going to say do pass.
Because of the amendment on it, yeah.
So just do pass as a committee
Do pass House Bill 25 by committee substitute. All those in favor indicate by saying aye.
Aye.
Any opposed? Okay. Thank you so much. That is all we have in front of us today. I do not know if we'll have a meeting on Tuesday. Mr. Carver, did you have something about court reporters you want to mention?
Yeah, I just conferred with Mr. Whip for a second. I thought that y'all be coming in. Do we know? Do y'all have a schedule for Monday morning?
You did great.
Okay.
But we are coming in on Monday.
Right. We have the court reporters are having a event and wanted to welcome all of the judiciary members.
Is it breakfast or lunch?
It's a breakfast.
Breakfast? Do you know where you'll be holding it?
But you know what? We may can change that.
Well, I suspect we're coming at 10, don't you think? No?
I don't know. We may start it.
All right.
I don't know for sure tomorrow. I'm going to do anything until tomorrow at lunch.
So our court reporters, which we all love, are going to have an event for the Judiciary Committee right here in 132. It'll be either be breakfast or lunch on Monday, and we'll have to just let you know. Okay? Thank you, Mr. Carver. Let me mention to you that I don't know yet if we'll have a meeting on Tuesday. We may, but I will tell you, I do know someone has this room now. So I know sometimes we linger and talk, so if you would go ahead and skedaddle, the chair would appreciate it. Y'all have a good weekend.
Thank you, Mr. Chairman.
Yeah, absolutely.
Thank you.